Okay, let's get right into it. For years, if you were on a government regulatory board, you were basically untouchable. Well, that's all changing. Today, we're going to break down a massive shift in the law that's finally holding these officials personally accountable for their actions.
So let me ask you this, and it's a huge question for any business owner. You get a decision from a board that feels totally unfair, maybe even like it's designed to shut you down. Can you actually fight back and sue the people who made that call?
For the longest time, the answer was just a hard no. These board members were hiding inside a legal fortress, basically built from all these different kinds of immunity. But here's the thing, that fortress is definitely starting to crumble.
So to really get how big of a deal this is, we first have to understand the fortress itself. Let's take a look at the legal shields that made these board members seem, well, invincible.
Think of it as a castle with 4 massive walls. You've got sovereign immunity, which protects the government itself. Then there's qualified immunity, which shields individual officials. On top of that, state action immunity protects stuff that's technically allowed by state policy. And finally, you have prosecutorial immunity for the investigators. Put them all together, and you had a nearly airtight defense.
Now that phrase right there, clearly established, that's the whole ballgame. To sue an official, you had to prove they broke a rule that was so obvious, so crystal clear, that any reasonable person would have known they were crossing a line. That is an incredibly high bar to clear. But then, 2015 happened, and a single Supreme Court case came along and basically took a sledgehammer to one of those fortress walls, changing the entire game.
And this is the case that kicked it all off. The dental board in North Carolina was mostly made up of, you guessed it, active dentists. And they decided they didn't like their cheaper competition, the teeth whitening kiosks in malls. So they sent out a ton of threatening letters to shut them down. Well, the FTC stepped in, and the whole thing went all the way to the Supreme Court.
And here it is. This is the knockout punch from that ruling. The court basically said, hold on a minute. If your board is run by people who are active players in the very market they regulate, they don't get a free pass on antitrust laws. The state can't just set up the board and walk away. It has to actively supervise what they're doing to make sure they're not just protecting their own wallets. So what happened after this ruling? Did it actually change anything? Oh, you bet it did. The floodgates didn't just open. They were pretty much blown off their hinges. Let's look at a couple of real-world cases to see what happened next.
Right, so 5 years later, this idea gets put to the test. Smile Direct Club sues the Georgia Dental Board, saying a new rule was basically cooked up just to hurt their business, and an appeals court agreed, saying point blank that the board members, as competing dentists, could be sued as individuals. Just like that, the shield was gone.
And here's why this matters so much. Check this out. In another huge case, the Texas Medical Board tried to kneecap Teladoc by requiring in-person visits. But just look at the costs here. The board's rule was basically trying to kill a $40 option to protect a $145 one. The court saw right through it, calling it what it was, protecting the market, not protecting patients.
Okay, so this brings us to the playbook. The old fortress is weakened. What are the actual legal tools you can use to hold a board accountable now?
So, you've really got 2 main paths under federal law. First, there's the Sherman Act. That's your weapon for antitrust violations, when a board is using its power to crush the competition. And its big hammer is something called treble damages, meaning you get 3 times what you lost. Then you have Section 1983. That's for when they violate your civil rights. The catch there is that qualified immunity can sometimes still be a defense. Let's just pause on treble damages for a second, because this is a massive deterrent. It's automatic. If a business can prove it lost, say, $1 million because of some anti-competitive rule, the court doesn't just award $1 million back, it awards $3 million. That's a penalty that board members simply cannot afford to ignore. Now, it's not just about civil lawsuits. Sometimes what these officials do goes way beyond just harming a business. It crosses the line into actual criminal conduct. And that immunity fortress, it offers zero protection there.
I mean, just look at this recent case from South Carolina. Now, it's not a licensing board, but it proves that a fancy title isn't a get-out-of-jail-free card. The state's former elections director ended up facing a whole laundry list of charges for using his job to enrich himself.
And look how specific this is. This wasn't some abstract crime. He was charged with embezzling a very precise amount of money, a little over $5,000 for stuff like gas for his own car. This is where that abuse of power gets very real and prosecutors get involved.
So let's pull all this together. We've seen the fortress, we've seen the crack in the wall,
And we've seen the new legal playbook. What does this power shift actually look like in the real world?
Well, the shift is pretty stark. Before 2015, board members could do almost anything with near total immunity, and there was very little you could do about it. But now individual members can be sued personally, they can face triple damages, and states are required to actually supervise them. The whole balance of power has changed.
So the takeaway here is really clear. The old playbook has been thrown out the window. The legal shields that protected board members for so long have been seriously damaged. Accountability isn't just a theory anymore, it's a reality. The question is no longer if board members can be held accountable, but who's going to be next?